finding out after the fact is like putting your seatbelt on after the crash. Sometimes people ask me the biggest mistake I see in the courtroom, and they're expecting to hear something like lying or not bringing evidence to support their allegations or to fight the accusations leveled against them. And while these are all big mistakes, there is one mistake that is bigger than all of them, and that is representing yourself in court. Huge mistake. It's like bringing a rubber knife to a gunfight. So I'm going to tell you a story in just a moment that will convince you that you should never go to court unrepresented. But before I get to that, picture this. You go into court with what you think is a solid family law case. You don't hire an attorney. The other party doesn't have one either, so why worry? You figure this should be pretty easy and straightforward, right? You'll put up your case, you'll present your evidence, and the judge, who has heard hundreds or thousands of similar cases, he'll understand you, he'll understand the other party. Your case is better and you're going to win your case, right? Nope, not so fast. The cold, hard truth is that representing yourself in family court or any court can be risky business. Why? Because judges, no matter how impartial they claim to be and should be, you know, the whole justice is blind thing, well, let me tell you the truth. Judges are only human and they are not perfect. They have biases, they have preconceived notions, and if you don't have an attorney, you don't know what you don't know. So you don't know if the judge is making a fair ruling. And finding out after the fact is like putting your seatbelt on after the crash. Family court is a place where the stakes are high, emotions run wild, and decisions are being made that can shape the course of your and your children's lives for years and decades to come. So here's a story that'll make it really clear what I'm talking about. We had a client come to us who represented himself in court in a legitimation case so that he would be declared the legal father of his child and establish his fatherly rights. And the mother was also representing herself. And he prepared his evidence to present in court about a number of different issues, as well as questions to ask the mother and information to present to the court himself. So according to his story, the judge didn't want to hear much from either one of them, and the judge did declare him to be the legal father, and the judge ordered that the 50-50 parenting plan that the parties had been following continue to be followed. Okay, sounds good so far, right? Well, here's where it went completely off the rails. The judge then declared that in lieu of the father paying child support to the mother, the father shall provide to the mother a vehicle that the father had purchased in his name and which the father was paying almost $700 a month for, and the father would also have to continue paying insurance on that vehicle. So we're talking about a total of almost $900 a month. Now the father also had to get himself a vehicle now because that one was being given to the mother and he couldn't keep up with the two payments, and the vehicle that the court awarded to the mother got repossessed. So what did the mother do? Well, she filed a contempt action against the father for violating the order, and then the father at that point hired my firm to represent him. So as soon as we saw this contempt action and the underlying order for legitimation, all kinds of bells and whistles and red flags went off. First, in a legitimation action, the court has no right to make an award of property. The only thing that the court can do in a legitimation case is one, rule on the legitimation. That is the establishment of a legal link between the father and the child, which allows the child and the father to inherit from each other. Two, rule on custody and parenting time and decision-making authority. Three, rule on child support. That is it. Even if the parties live together, even if they bought a home together and filled it with furniture that they bought together and saved money in a joint account and ran up joint credit card debts, the court cannot rule on any of those issues in a legitimation case. Only the three that I just gave you. Now, in a divorce case, yes, all of those are up for determination, but not in a legitimation case. Not in this case that my client went to. Legitimation, custody and parenting time, child support, that's it. Tell me something. Are you aware of what I just explained to you? If that had been you, would you have known what the limitations are on what the court can and cannot do? Would you have known that you should always, for instance, have a court reporter capturing the proceedings for the record in case you need a transcript later for an appeal? So continuing on with this story, our law firm went to court and the case was heard before a different judge than the one who issued the original order on the legitimation. Now, before the other side could even put their case on, we made an oral motion to dismiss that case, to throw out the contempt, and we explained to the judge that it should be dismissed on two grounds. The first being that the judge in the legitimation case had no authority to issue an award of property, i.e. the vehicle, in a legitimation case. The second ground was that even if the original judge or this judge here in the contempt case or the mother and her counsel, which by the way she hired one this time around, even if they were all inclined to argue that the payments on the vehicle and its insurance were in lieu of child support, which is what the original legitimation order said, the judge in the legitimation case still had no authority to do that either because, and hear me carefully on this, it is the law in Georgia that an award of child support must take into consideration the financial circumstances of the parties, which typically means their incomes, and the amount of child support must be calculated using a child support worksheet. The judge didn't do any of that. He just said, pay for the vehicle and the insurance in lieu of child support. That was a total abuse of discretion and a total error in applying the law. It would be like the IRS knocking on your door going, pay this amount of taxes without even looking at what your income was or running it through their tax tables. See, you would spot that immediately, but when it comes to going to court on family law matters, it's not so easy to spot if you're not familiar with it and don't understand it. So how did the judge rule in the contempt case that was filed against our client for allegedly violating the underlying order and legitimation? Good news, the contempt action was dismissed as being void ab initio, which means invalid from the beginning. So what's the lesson here? It's that courtrooms are dangerous places for litigants because you can't predict what's going to happen. And if you assume that the judge or the jury is going to get it right on their own, you're wrong. So how do you protect yourself? Well, you hire a fantastic attorney who has a deep level of knowledge and expertise and experience in whatever legal area that you're going to court with, and take them with you as your legal warrior and your bodyguard. That's what we're all here for. That's what attorneys do. Having somebody who completely understands and can apply the law to your case while you're in the courtroom can save you the unbelievable stress and grief of trying to fix what got messed up in the courtroom even before it makes it to paper. I have personally seen how some judges treat people who represent themselves. Some are more deferential to them, some let whatever happens happen, and some are cruelly dismissive to those who try to represent themselves. In this case that I just told you about, if our client had had an attorney for the original legitimation case, I could pretty much promise you that there would have been a proper hearing. Both parties would have testified, evidence would have been put forth, and there would not have been any rogue decisions by the court. The judges know that the attorneys know what should or shouldn't be done and what can or can't be done by the court. Now, the judge in the original case knew the law and knew exactly what they were doing and did it anyway, and there's no excuse for how they ruled. Our client ended up spending thousands upon thousands of dollars making payments on a vehicle which they should not have had to make. And then they spent money hiring us to defend them in the contempt action. They would have spent less money if they had hired an attorney from the beginning for the underlying legitimation case. And guess what? Even the other side would have saved money if our client had had an attorney in the legitimation case, even if they didn't have one. Why is that? Well, because she would not have wasted money trying to enforce an order that was improper and void from the start and therefore couldn't be enforced. So to wrap up and summarize, if you're thinking about going to court solo, ask yourself this: is saving a few bucks worth the potential cost of getting legally screwed and having to spend more later on? When it comes to the law, ignorance is not bliss. It's a ticking time bomb waiting to explode in your face. So hire an attorney to not only represent your interests and put together and present a coherent case, but also, and this is really important, to prevent the judge from going rogue and doing whatever they want because they know that you don't know the difference between what's legally allowed and what's not. We do, attorneys do, so let us protect you and your kids. Hey, thanks for watching this video. Be sure to click subscribe, like, follow, and turn on the alerts so that you'll get notified when we post our newest videos. And please share these videos and leave us some comments, ask us questions, tell us what other topics you'd like me to talk about. Join our Facebook group at Georgia Divorce and Custody for more information. And as always, I look forward to seeing you on the next video.